Did you know that one of the fastest ways a nurse in California can lose their license is by trusting the wrong turnkey Medspa consultant? If someone told you, just form an LLC and you can start injecting, it's that easy, you may already be in danger. Today, we're breaking down the just start an LLC trap and how it's putting California nurses, NPs, PAs, and even physicians at risk. Hi, my name is Andrew. I'm the managing attorney here at FreedomThruBusiness law firm. We help nurses, nurse practitioners, PAs, physicians start compliant healthcare practices while protecting their license. The businesses we focus on include med spas, IV hydrations, and wellness clinics. We've helped launch over 100 healthcare practices here in California and defended licensed providers during investigations and board audits. I see the just start an LLC horror stories every week. There is a huge trend right now. Companies marketing turnkey med spa packages. They say things like, we'll set you up in 30 minutes. Just sign here. We provide the doctor. You don't need a medical corporation. An LLC is fine. We will automate compliance for you. They say things like, legal documents are included. You don't need a lawyer. Sounds great, right? Wrong. Here's the truth. Most of these companies are not law firms. They are not licensed to give legal advice. They are not accountable when a board complaint shows up. And finally, they don't protect your license. You carry that risk. When lawsuits or board complaints come, the third-party turnkey companies, they disappear. And you're left saying, but they told me this was legal. The board doesn't care. This language is straight from the Medical Board of California, and I will read it. Only a licensed physician may own a medical practice in California and may employ other licensed healthcare professionals. They explicitly warn against illegal med spa structures and unlicensed business ownership. This is part of California's corporate practice of medicine doctrine. If you are a nurse and someone gave you an LLC to run a med spa, you may already be violating CPOM. The public BRN discipline records show nurses losing their licenses for the unauthorized practice of medicine, administering treatments without proper protocol, operating unlawful medical businesses, and working under illegal medical director arrangements. And in nearly every file, you see the same language. Respondent believed that they were authorized by a business consultant. Belief is not a defense. Intent is not a defense. Ignorance is not a defense. The board expects you to know the law. You are a licensed healthcare provider held to a higher standard than your ordinary reasonable person. So here's how nurses really get trapped. Third-party company markets fast med spa setup. They then tell you, next they'll tell you to form an LLC. They will then assign or rent a medical director to yourself. They hand you PDFs and call it compliance. You start treating patients. There's a patient complaint or a board inquiry happens. They vanish and you face the board alone. That 5-minute onboarding call can turn into license suspension or revocation. Thousands of dollars in defense fees. Criminal exposure in extreme cases. Major civil liability and public record of discipline permanently online. Fast and cheap becomes slow, expensive, and career-ending. Before someone injected anything in California, they completed thousands of hours of clinical training, spent tens of thousands in intuition, passed state exams, earned a professional license, and you're going to risk all of that on a $5,000 turnkey med spa package and a Zoom template? Don't let social media marketers put your livelihood at risk. Before you sign any med spa startup contract, make sure you ask some of the following. Who is legally responsible for patient care? Who holds ownership, and is it CPOM compliant? Is a physician truly supervising? Ask questions such as, are there standardized procedures? Who drafts those standardized procedures? Who signs those standardized procedures? Are they California compliant? Is there written medical oversight and chart review protocol? Who pays the MD and how? No fee splitting. And finally, who defends me if there's a board complaint or a patient complaint? And one more key question. Are you a law firm? If the answer is no, they should not be giving you legal documents or legal advice. Remember, if someone says no ownership rules apply, don't worry, run. If someone says all RNs can own med spas, run. If they say we already have medical directors, it's just plug and play, run. Healthcare law does not equal Shopify. You are not selling t-shirts. You are practicing medicine under one of the strictest medical boards in this country. License is not a side hustle. If you're building a med spa or IV hydration business here in California, make sure you form the correct entity. Professional Medical Corporation for the clinical side and an MSO for the administrative side. Have real legal agreements, specifically drafted for healthcare, not templates, not copied PDFs. Additionally, make sure you have real standardized procedures, signed, dated, and physician reviewed. Make sure you have real oversight and documentation, chart reviews, logs, policies, HIPAA notes, HIPAA protocols. Have a lawyer who can form it right, explain every step, and represent you if something happens. Startup plus defense equals real protection. You work too hard to gamble your license on shortcuts. You deserve a compliant business, a secure license, future you own and control. If you're serious about building a compliant and long-lasting med spa or IV hydration business here in California, make sure you subscribe. This channel helps protect healthcare providers before and after you open. And if you want help the right way, make sure you book a free call by using the link in the comments below. Freedom Through Business. Let's get involved.